Good morning, everyone. You'll see that there's a QR code on your screen. For those that haven't participated yet, please take your phone and scan the QR code. It's just a fun little bit interaction with you guys. The results are anonymous, and we'll share it in a few minutes with you. Welcome, everyone, and thank you for joining this session today, where we're going to talk about POPI and what has been happening in the last few years. My name is Vilmarie, and I will be presenting today with my colleagues Priyanka and Naledi. Priyanka, there seems to be a lag on my side here, so if you can just... So just a quick overview of what we're going to discuss today. We're going to look at what happened in the last 4 years since POPI was implemented, looking at some of the trends. I think what a lot of you are here for, looking at how does it look when the Information Regulator come knock on your door and come do POPIA and PIA audits. Everybody in our panel here has been involved in some of those audits with clients of ours. So we hope that we can give you some insight and learnings from those audits so that you know what to expect when you get a notification of an audit. And then looking at a sustaining privacy program and some action-orientated checklist. So looking at where we are and what has happened. Priyanka, can you please move the slide? So it's been 4 years, and it's been, I can't even believe it is 4 years. I remember when POPI was implemented in July 2021, it was in the heart of COVID, and we were all waiting for that announcement that POPI is going to commence. And I know we all certainly said it will definitely not be now. It was COVID crisis. It was a hard lockdown. There's no way that government will put this implementation burden now on everyone. And we were all wrong, because the next minute there was a notification that POPI will become effective, and everybody had a year. And I remember us all sitting at home and frantically helping clients to start implementing POPI. But 4 years later, we've seen quite a bit of movement, quite a bit happened, and we'll talk a bit more about that. We've seen the new e-portal. In the beginning, you could only register your information and deputy information officers online. These days, you can also, or you must also, register your breach notifications and your annual PIA reporting. So quite a bit has changed. If we look at the trends over the last year or so, or what it is we're seeing, we've seen that a lot of companies with the initial implementation have policies and procedures in place. So there was this big rush of, we need to get certain policies in place, and a lot of organizations have done that. What we see, and what we see the regulator really focus on, is that there has been no refresh or audit of these policies. There's been very little operational implementation. So, if we use an example, companies implemented a document retention policy, but very little of that has actually been practically implemented. So we see policies being there, but not a lot of operational implementation, and not a lot of audits, not a lot of privacy impact assessments or data risk classifications being done. And interesting enough, when Priyanka takes you through the POPI audit process later on, the regulator, when they come to your office, they're going to ask you, oh, how is this being implemented? Show us your processes. What are you doing? So just having a policy and saying to the information regulator, oh, here's my document retention policy, is not going to be enough. So we've seen a lack of actual implementation of policies. We've seen a lot of people have operator agreements or DPAs, data processing agreements, whatever you call them. A lot of companies are signing that, but we're seeing a lack of any third-party assurance or monitoring of actual compliance with these agreements, monitoring of actual security standards. We've seen compliance with reporting obligations for significant security compromises. We think there's an underreporting of the, let's call it, smaller security compromises. We've noticed that with the initial implementation, there was a lot of initial staff training. There has been no or very not sufficient ongoing and targeted staff training and awareness around POPI. We've seen privacy notices and PIA manuals, cookie notices to a lesser extent, cookie banners on website. We haven't seen, and especially our team does a lot of due diligence work. We often find that the PIA manuals are outdated and have not been updated. There's been new forms published, new contact information for the regulator. Your data processing might have changed. And I think it was one of those that, oh, we have a PIA manual, it's there, and we never look at it again. So we find that a lot of those manuals are 4 years later very outdated. Registration of information officers and deputy information officers. We've seen like most of organizations have done that. We haven't seen lots of tailored training for specific risks for information officers and deputy information officers.
Okay, so
in terms of compliance, Priyanka, what is our poll saying?
I'm seeing a lot of interesting responses. 68% is people saying that they're somewhat confident that they are regulator ready for if they get an audit. But we have 21% people. I chuckle, but we'll see. But 21% are very confident. They say, bring on the regulator, they're ready. And then we have about 11% people saying somewhat confident, and then a minority of people are saying that they're not all confident. They haven't revisited their POPI compliance since 2021. So it's good to see that kind of feedback from the room. So that's interesting to see. We are going to run this poll again at the end of the webinar just to see if you still feel the same way.
See if you change your mind.
Yeah. Okay, we can move on to key developments in our next section.
So in terms of key developments, what we've been seeing is that the Information Regulator is starting to send out a whole lot more of information notices. So basically an information notice is what it says. It's the information regulator sending a notice or a letter asking for specific information. Sometimes this comes prior an audit or an assessment, or sometimes it comes after an assessment, depending on how the assessment goes. So that's basically what an information notice is. And this is part of them enforcing their powers, especially when it comes to ensuring compliance with POPI and PIA. Another key development that we've seen in the last 3 years specifically is enforcement notices being published, as well as a fine having been imposed specifically on the Department of Justice and Constitutional Development. Now, I know we always are scared when we hear the word fines because a fine can go up to 10 million. But I think it's always important to remember that the fine isn't just issued upon non-compliance or a finding of non-compliance. So there's a whole process that happens, is that the information regulator will conduct their assessment. On conducting their assessment, they'll then publish an interim notice to the responsible party, telling the responsible party what they need to do, and telling the responsible party what they need to do. And this is the enforcement notice. And if you don't comply with the enforcement notice, that's when the fine comes in. So there is always an opportunity for responsible parties to remedy non-compliance before that fine is imposed. So we've seen quite a few, I think there's around 6 or 7 enforcement notices that have been published by the Information Regulator to date. A significant one I just spoke about is for the Department of Justice and Constitutional Development. And they were issued with an enforcement notice because they failed to comply with Condition 7, which speaks to security safeguards. Among some of the issues was that they didn't have basic security safeguards or standards such as antivirus. And as a result, there was a big security breach. And they failed to actually remedy that post getting the enforcement notice. The other one is a enforcement notice that was imposed on FT Rams Consulting. And this one had to do with non-compliance for direct marketing under POPIA. There was no fine there, so I think they did remedy some of their non-compliance issues as stated in the enforcement notice. And then also the Department of Basic Education, I think this is one of the most recent ones where there was a failure to process personal information based on a ground of justification. This was when the Department of Basic Education wanted to publish the matric results in a newspaper, and I think it also went to court, and there was quite a big a dispute over what should be done. And the Information Regulator actually found that you do not have a basis to publish all this information on newspapers so that it's publicly available. And so then the department was asked to not publish and to rather find other means and making sure that matriculants and students could access their results.
So something that we're going to be covering a lot will be audits. So I'm not going to get into a lot of detail regarding that on this slide, but we call them audits. I think the regulator uses a bit of a softer word, just, a visit. It's not as aggressive as the word audit suggests. So we'll take you through POPIA audits and POPIA audits in a couple of minutes. But that is something we're seeing a lot in the last few years. It's usually following such a visit that there will be those enforcement notices that we are all seeing being published by the regulator on their website or their LinkedIn page. So those audits are often, very consultative. There is a process of information gathering that would lead the regulator to draw up a report that results in their enforcement notice that is being issued. And just something to note is that the enforcement notice that is issued is a lot more simplified, the one that is publicly available. The entity itself will get a comprehensive document, but that whole document is not published typically by the regulator on their public platforms. So audits are happening a lot, and that's the focus of our webinar today. Another big development that happened just this year, a couple of months ago, was the POPIA regulations that were initially implemented several years ago have now been updated. So there have been quite a few developments regarding those regulations, and I'll take you through just a couple of them in a second. But the main purpose of the update seems to be that data subjects' rights are just easier to exercise. They've come up with more practical ways to exercise existing rights. So very important, there's nothing in the regulations that amends POPIA itself. It's process-based. So for example, ways in which a data subject can request access to their information or correction or destruction, anything like that, those processes have become a bit more streamlined and easier for the data subject to actually process those requests. Another interesting thing is that there are reinforced responsibilities for information officers. So we'll show you that towards the end of the segment when we're looking at maintaining a living privacy program. But information officers still have the requirement to implement compliance frameworks, but there's more of an ongoing and continual improvement focus from the regulations that have been amended. Interestingly, they have deleted the requirement to make POPIA manuals available under Regulation 4 as an explicit obligation of an information officer. So now that just attaches to the whole entity, rather than it being an explicit obligation of the IO only. So again, I think there's a possibility there of there being some streamlining, because POPIA obviously still applies. The requirement to have a manual still applies, all of that. And the last notable change, just to comment on from the update to the regulations, is direct marketing. So still, the direct marketing provisions under POPI still equally applicable. They haven't changed anything from even their guidance notes that they issued in December last year. But what they have changed is the form that we gather consent for opt-in for direct marketing, which is a welcome change. Previously, under the original regulations, organizations had to follow Form 4 almost to the letter when they implemented their opt-in for consents for direct marketing, if it was a tick box on the website or a tick box in a contract at the bottom of the form or anything like that. Form 4 was actually quite unwieldy, very clumsy, very comprehensive. And now what the regulations have done is to say, well, it can be a bit more practical. It can communicate that a bit more differently, as long as we are looking at getting consent in any manner that is actually expedient. So it doesn't have to be through that very rigorous process. So even things like WhatsApp, SMS, all of that are perfectly fine. So that's it on POPIA regulations. Over to you, Vumri, on the rest.
So we've also, like Priyanka just mentioned, seen some guidance notes. A few years back, it was on prior authorization. More recently, towards the end of last year, on direct marketing. Trying to give more guidance and clarity on what kind of practices are seen as direct marketing when legitimate interest is used as a ground for direct marketing. Obviously not when we're talking about electronic communication, direct marketing, but other categories of direct marketing. And you use legitimate interest as grounds for that where you don't have consent. The need for a privacy impact assessment and to determine legitimate interest grounds. And so they provide quite a bit of detail on how that impact assessment should look. Obviously, taking into account that as the responsible party, the obligation will be on you to ensure that you can show that you did that impact assessment and that your legitimate interest does not outweigh the interest of the data subject. And as Priyanka said, the most recent change to that was the change to Form 4 and just making it a little bit easier to obtain consent through various platforms. We've seen numerous codes of conduct that's for industry specific that's published on their website. I'm not going to go through those. You can go look on their website if you want to know which industries have approved codes of conduct. We've seen some new legislation come out, especially in the financial services industry, like the Joint Standards 2 and Joint Standards 1, that specifically also addresses confidentiality and data privacy principles and issues for financial institutions. And then obviously emerging technologies, AI is very topical at the moment. And we've also seen changes in that and massive impact that have on data privacy. So it will be very interesting to see how the regulator is going to approach that. And if we're going to see maybe a guidance note on AI soon. Then moving on, we're going to look at our first topic, which is POPIA audits. So what is the regulator's enforcement powers? So in terms of Section 89 of POPI, the regulator can on their own initiative decide to do an audit or an assessment. Like Priyanka said, we call it audits, but the regulator refers to it as assessments. So they can decide to do an assessment, which is what they've been doing with POPIA and POPI. They've been doing, I would call it like the road trips or road shows where they go. They've picked an industry. So I know with POPIA last year, they pick specific industries and they then just go through that industry and target them with audits. They can also decide to do an audit based on a data breach or complaints. So we have seen certain companies that received audit notices based on various complaints or based on various data breaches. So there's various reasons why the regulator may decide to do an assessment. They are at the moment, like I say, just doing run of the mill. So it may not be that you have done anything to trigger them to look at you. It's just they're doing run of the mill POPIA and POPIA assessments. And then, like Naledi also mentioned, they'll normally issue enforcement notices. And as we go through the process in more detail now, we'll talk a bit more about how do they deal with the assessments and their findings. So if we look at POPIA audits, what to expect. So normally what they will do is 1 month, we've seen shorter notice, they will you'll receive an email from the regulator and they'll normally send it to the information officer, so the details that they have on their system for the information officer, informing you that they're coming to do an assessment. They'll give you a date and a time when they'll be at your offices. So this is not a check your diaries, does this suit you? You will receive a notice to say on this date at this time we'll be at your offices. They will inform you they'll send you like a agenda, so they'll inform you exactly what it is they're going to look at and what information it is that they want to receive from you. For the POPIA specific, checking and reviewing your POPIA manual and privacy notice on your website. So that is specific things that they will come look at as well. So they normally do that before the audit as well to see that those things are there, and then request send questions around that. And like I said, they will give you a formal agenda for the day. The assessments that we've attended, there were between 2 and 3 people from the Information Regulator. Normally one of them very senior, so they don't, it's not people that don't know what's going on, or very junior people that they normally send to this assessments. And the POPIA assessment is normally a few hours. I don't know about you, Priyanka and Naledi. I haven't seen, it's not as lengthy as the POPI assessments that I've heard some of them go for up to 5-6 days. The POPIA assessment is a bit shorter, and it's normally, I think, and the ones we've went, they booked half day, but it went a bit quicker. So what to expect on the day? Or before the audit. Okay, so before the audit, what you need to do, you will have the agenda. So it is just gather all your relevant information and documentation. Identify who needs to be in the audit. You are allowed to have legal representatives. So it may, I haven't, well, obviously we've been to a lot of them to assist clients. It will normally be the information officer. Specifically in the POPIA audits, it was the information officer, deputy information officer, and then we were there to assist them. I think in your POPIA audits, and Priyanka will touch on that, your panel will be a lot wider because the topics they discuss is a lot wider. It will touch on IT security and all kinds of things. So go over your policies, your POPIA manuals, to look out that everything for errors and that everything is in order. If there's any shortfalls, I'll take you through what is the kind of things they look at now. And then have a document pack ready for them, like print it out, have it ready, have a file ready that you can give to them when they get there with all the relevant documents that they've asked for and that they want to see. And then ensure that you prep your staff ahead of the audit so that they know what to expect. So if we go to the next slide, you will see that when the auditor, and we've seen this at many of the audits that we've attended. By the way, ENS had a POPIA audit ourselves, so they came to our offices also to do a POPIA audit on ENS. We note that they asked the receptionist or whoever's receiving them, and even just staff around, whether they know who the information officer is. So they're testing to see if there's awareness and if staff knows who the information officer is. So very important, especially if you're a large organization, that you have awareness campaigns, maybe just frequently informing your staff who your information officer is. I mean, they're supposed to know that, because if there is any data queries, it needs to be directed to the information officer, but it is something the regulator specifically asks people random questions to see if they know who the information officer is. While waiting at the reception, they looked to see if there were a copy of the POPIA manual, as well as the POPIA guide, which has to be there in 2 official languages. The guides are available on the Information Regulator's website in, I think, all 11 languages. So you can choose which 2 you want. We normally suggest that clients choose, obviously have English, but then choose a language that's most prevalent in the area or the province or location where your offices are situated. When they came to visit us, they actually took pictures of the POPIA manual and guide at the reception. So yeah, they do ask to see that and then check whether that is actually there. Then during the audit, they actually checked and they actually went onto the website in the audit session, to see that the POPIA manual was there. They did tell us that they looked beforehand as well, but they go through it with you. They want to see that all the forms, so one of the changes in the new regulation was updated forms. So your Form 1, Form 2, Form 3, you don't need Form 4 on your website. They check that those forms are easily accessible or available on your website. They prefer it if the forms are, if in your POPIA manual, you can click on the form, or it's easy to download. They had a lot of questions around how do we make it easy for people that don't have access to print or to download. How do we make it accessible and easy for people to actually get that forms. So the simpler you make it, you can even have online forms, but they do check that those forms are all on your website, that it's the latest version of the forms, and that it's easily accessible by data subjects. They then go and they work line by line through section 51 of POPIA. So they will page through your POPIA manual, and they will interrogate every section. They have a form that they fill in, and they tick whether your manual complies. So they'll look at, say, for instance, does the manual contain the name and the updated contact details of your information officer? And then they'll see, yep, it's there, and they'll tick it. So they want to see the information officer's name. They want to see an email address. They were happy with a generic email address like information officer @ or privacy @. There must be an adequate description of the guide. So again, the POPIA guide and where you can obtain it. They want to see a list of categories of information available without a POPIA request. So this would be your publicly available information. So normally it's things like information available on our website, our marketing materials, so anything that is public information about your company. What is those kind of documents, and where can I get a hold of it? They actually went to go look on our website to see where the information is available. They want a description of records available in accordance with other legislation, and they wanted those tables to be linked. So they want to know in terms of labor legislation, this is the documentation that's available. In terms of this legislation, that is the documentation that is available. They wanted to see a description of all data subject categories and the types of data that is held. So for instance, that would be in our organization, our data subjects are employees, and we have the following categories of data of employees. We have customers, and we have the following information of our customers, of suppliers, of whatever other shareholders, whatever other categories of data subjects you may process information of, and then the type or category of data that you hold. The purpose of processing, so whether that is set out sufficiently in your POPIA manual. Also, something that is important to update from time to time as your organization's processing activities change. Recipients who you share information with. Transborder flows. So is there a proper description of how you send information outside of South Africa? And information security measures. They didn't want a one-liner that just says we implement adequate security measures. So we had a bit of a debate with them around this, because setting out all your security measures and standards in a public document in itself poses a risk, because now you're publishing to all or any hacker out there what security measures you have in place, and it makes it easier for them to see, oh, well, they've only got that, let's circum. So we did say to them there needs to be a balance between, and they did understand that they wanted simple things in there, like, do you encrypt certain documents, or do you, so they understood that the information security measures would be very high level in the POPIA manual, not in a lot of detail. Next slide, please.
Can I actually ask something about that?
Yeah.
I haven't done a POPIA audit the way you and the lady have done before, but a lot of the things that need to be disclosed in the POPIA manual overlap with what needs to be disclosed in a privacy notice as well.
Yeah.
Did they comment on whether it's enough to even hyperlink the privacy policy that the organization has, or is it more of an operational issue for clients to make sure that there's a back-to-back, like what they have in their manual, they also have in their privacy policy?
Yeah, I think it's the latter. So they are very, they don't like hyperlinks. Even with the POPIA manual form, they didn't really like hyperlinks. They want to see the actual information in your POPIA manual. And so it will be on you to ensure that, so they see the privacy notice as your Section 18 notification, and that would have to be aligned with your POPIA manual. So when it changes in the one, it will often change in the other, because like you say, a lot of the things we talk about here, like what do we do with your information? How do we share it? Will have to be mirrored between the two. So often when we look at privacy notices and POPIA manuals, we make sure that the two speak to each other. So yeah, I don't think they will be happy with you not having that information in your POPIA manual and just say refer to our privacy policy.
And I think the one thing I've also picked up in the audits that I've been a part of is that there is I guess what they're trying to reinforce and state is that there's two different divisions in the Information Regulator, for POPIA and for POPIA. And so the two are separate, and in as much as they speak to each other, you're dealing with different people and you're dealing with different requirements. So, that's something that at least I've heard quite a number of times, and to always be aware of. So even if your policies or your privacy policies have all this information, your POPIA manual still needs to have all that information, because you're dealing with separate bodies in a sense, or separate divisions. And so you need to show compliance as per the legislation, and not necessarily, the full data protection legal framework.
Yeah, you're very right, Naledi. And it's a good reminder that your POPIA manual is regulated under the POPIA Act, whereas your privacy notice is regulated under POPI, and they do audit those differently, and it is different divisions that very separately look at that. So yeah, that's a very good point. Another reason why you have to have them separate. So in your POPIA manual or POPIA assessments, they didn't even ask about privacy notices, but they will in the POPIA assessment, definitely. They also ask for proof that you have submitted your annual PIA report, so that you'll just print out and give them as part of the pack that you prepare for them. They want to see the information officer and deputy information officer delegation forms and appointment and registration forms. So you'll just print whatever delegations or appointment letters you have for them, and then your official certificate that you got when you registered them, and put that in the pack. They insisted in more than one audit, definitely in all mine, and Lydia, I don't know if you experienced the same, that all private organizations must have a deputy information officer. And we had quite a debate with them around this. They referred to specific wording in the Act. And yeah, I mean, I think in most of the audits we did, it was larger organizations, and we just decided that it's not worth, even with ENS, it's not worth arguing with him, or we just said, fine, we'll appoint a deputy information officer. Naledi, did you find that in your audits or assessments for them as well?
Yeah, I think though in the organizations that I was with, the responsible parties, they had already appointed a deputy information officer. But I did ask in terms of what's their reasoning and why do they think that this is, outside of it, why do they think that that's the case? And one of the members from the Information Regulator said it's more of managing all of the things that have to, all of the obligations, especially in big organizations, especially, with this understanding that an information officer does not have sight of everything that's happening in an organization. And so having a DIO and having or multiple DIOs helps to make sure that different divisions or different areas in an organization are actually being attended to, and there's someone who has oversight in terms of data privacy compliance in that way. So I think it's also more of complying with the spirit of POPI and PIA, and that's why they would insist on it.
Okay. Then they also wanted to see policies relating to the implementation of PIA. So it will be your, do you have any policies in terms of data subject access requests? So they asked quite a bit of questions around practically how do you deal with PIA requests or data subject access requests or requests for amending or deletion of documentation. They wanted to know whether we have received any such requests. So they ask quite a bit of detail around PIA requests that have been received and how it was responded to, and what processes are in place to deal with it. They wanted to know who receives the PIA requests, and they spent quite a bit of time interrogating the process that is followed to consider and respond to those requests.
I also wanted to just add some things. I'm seeing a lot of stuff in the Q&A as well. Someone's commented that there are no new forms available on the regulator's site, and the template manual hasn't actually been updated yet. Yes, tread carefully with some of the templates on the regulator's website. I've also noticed that the forms that have now been amended by the new regulations haven't yet been pulled through, or the last time I checked, haven't yet been pulled through to the regulator's website. So, when you are including forms that are in the PIA manual, as advised now by Vomriana Lady, make sure you're using your primary piece of law, which is the regulation itself, and not information that is on the regulator's website necessarily. The regulator has also said, even in the next section I'm going to discuss now on POPI audits, is that even if they have made an opinion or expressed an opinion during an audit, it doesn't necessarily mean that that is law. It's also their interpretation of law, and anything the regulator does can be challenged in the courts of law. It's not that their decision is absolute. They are held to the same standards as any other body in the country, and even higher. So in terms of our law, there are things that can be challenged. So we can't take what they say at face value. It is important to still get legal advice, or really consider that, for example, the manual that is on their website is not them saying that this is the official manual all organizations have to use. That's the interpretation also of the act and what needs to go in. So just always double check those things as well, that you do find, like the templates and even the guides. I mean, something we've been discussing for a very long time are the guidance notes are not legally binding. It's persuasive, because the odds are the person who's going to be enforcing action against you will likely be the regulator, and that guidance note contains their view. But there have been some things in the guidance notes that we in our team have disagreed with, as not being correct interpretations of the acts. So just to be mindful of that.
And then just to close off my section, so what happens after the POPIA audit? So that checklist that I mentioned in the beginning, that they sit there and tick every section of the act, whether you comply or not, you'll get a report back from them with that, incorporating that checklist where they say compliant, non-compliant, compliant, non-compliant. And then they'll give you a certain amount of time. What was it, Naledi, 30 days or 60 days to remedy. So they'll make certain suggestions and then ask you to remedy it and to send them kind of proof, or that those things or their suggestions have been implemented. Or you can query it, or you can appeal to their and say, oh, you don't agree. Their suggestions have never been the ones we've dealt with. Even though we might not have 100% agreed that we have to do it, it was easier to just implement it, because it was simple things, than to have a whole fight with the regulator. So, but I suppose it depends on their ruling. We haven't seen, especially in the PIONs, any really unreasonable rulings. So, yeah, they will send you just their form, and you can then go back to them and say, all of this is done, and normally that's the end of your POPIA assessment. So Priyanka, you will talk to us about the lovely POPIA assessment.
POPIA orders. I also wanted to share with the panelists, I'm seeing some messages pop up in the chat saying that they had initially responded saying that they were somewhat confident about being ready, but they actually want to go back and change their answers. Look, I mean,
I think they'll feel more so after your section.
Yeah, but look, we hope so far. We're halfway through, but we hope the content is at least helpful in giving everyone some sort of peace of mind of what still needs to be done, at least to get you there. The POPIA audits, this is sort of my section that I'm going to be talking through, and the various ones that I've been involved in for clients from different industries. It's kind of following the same approach as Vilmarie just discussed with the POPIA audit. Their process is very similar. You'll get a letter or email from the regulator addressed to the person they have registered, which also comes back to making sure that you are updating those details and it's not someone who's now left the company, because that'll make it difficult for those communications to be monitored. So obviously something to keep an eye on is making sure your IO details are kept up to date. With the POPIA audits that we've seen, they have, triggered by different things. A data breach notification. So if you filed a notification with the regulator, as you are supposed to be doing, and you communicate a data breach, not all of them will result in an audit. It does depend on the nature of the security compromise, the impact to data subjects, any sort of concerns that the regulator might have regarding the context in which the security compromise took place. So it could be off the back of those notifications that were filed that you're now receiving this communication from the regulator to do a visit at your offices. It could be complaints, as Vilmarie mentioned as well, with the POPIA audits. Complaints we're seeing a lot in the context of direct marketing that organizations are dealing with, or allegations of unlawful processing, which is a very wide allegation, which is probably why it would make sense for the regulator to try to interrogate the allegation. Often what the regulator would do, though, when they receive a complaint is they do invite the organization to respond first and, give their view. So that will probably be what happens first before there is the visit that is done. Or it could be completely random. As Will Marie mentioned, there's a lot of, they're kind of following a bit of a roadshow, looking at industries. So it could have been that, company A was affected by a data breach, but given their industry, given the type of information they're processing, they think, okay, let's look at all the other companies that have similar sort of processing activities, similar impact to data subjects, and let's just have a look at all of that. Which I think is quite good, and a nice approach for them to be following. Types of audits that we're seeing. So a visit, it could be a visit, it could be in the form of an information audit. They might not actually come and visit you at your offices. It could just be asking, for your evidence of POPIA compliance. I'm going to discuss both. The ones that we've dealt with have been a hybrid, where there's been a visit that was followed by an information notice that was issued to the company asking for various documents to assist the regulator with preparing a report off the back of the visit. So the first one, and perhaps the scarier one of the two, is the visit from the regulator and how that rolls out and how it's implemented. So you would get a heads up. It's typically a reasonable time. It wouldn't be a reasonable time if you don't have anything in place. We have seen organizations scramble because they haven't done anything for several years since POPIA came into force, and that's why even a heads up of 3 weeks might not be enough. So that 3-week heads up is there, or whatever the period is, it's there to just make sure that you are prepared for the audit. And very similar with the prior audit stream, it's not like you have any say in when to be available. They'll say, we're coming on this date or these dates. You need to make your offices available. You need to have facilities available to accommodate our staff. And they do come, it depends on the audit and the extent of it, but they can come with a team of, up to 10, 12 people from their side. Each person from their team has different areas of focus as well, which I'll discuss in a sec. But that period of like the heads up that they give you is really there for you to just get your ducks in a row, be prepared. The way you would for an exam that's coming up, like the information is all there, but you're just doing your last minute revision. So you're also allowed a legal representative, or several, if you want, that you can attend. Sorry, this thing is skipping. I'm not sure why. But yeah, so you're allowed a legal representative to attend the audit with you. The ones that I've attended with clients, it's not a litigation. It's not a courtroom. You don't want to be hostile in an audit. It's actually a very informal discussion that has formal consequences, but it's a very informal discussion that the regulators team has with you. And from an optics perspective, it's actually good to have your information officer and senior stakeholders there to drive the discussion with your legal as your support. You don't want your legal to be taking over the whole audit and all the questions that you get from the regulator. It might be seen as very defensive and potentially hostile. The approach that I've followed in the audits I've done with clients is you almost, as the lawyer, you say, look, this is our interpretation of the act. This is what we have in place. What is the regulator's view on this? Or what do you guys think? It's not to say we're right, you're wrong, we don't agree with the finding, because it's a collaborative discussion. It's a very deep discussion that you can have, and it's an opportunity for you to demonstrate what you have in place and to also admit that, hey, maybe we haven't thought of that, and that's okay. It's not an opportunity to lie, obviously, and be deceitful. So that's an important thing to bear in mind. The legal consequences of these audits is that the audit itself is not going to result in a fine. As the lady said, there is a process that leads up to the enforcement notice being issued. if there is one. So what typically happens with these visits is they come to the offices, they ask a bunch of questions, they make their notes, these sessions are recorded as well. And then they go back and they sit with all the information that's been given during the visit, or during, if they had requested any further information after their visit. They use all of that information and they prepare a report. And that's a draft report that they prepare, and they will issue it first to you as the responsible party before it becomes final. And they'll actually invite you for your representations on the report. They'll actually say, this is our intended report. This is where our findings are going to be. And they'll invite you to make comments or say, we don't really agree with this finding. Did you remember to consider this document that we had provided? Or it looks like you didn't consider this. We actually do have a privacy notice for our employees, and things like that. So there is an opportunity for engagement. And then after that engagement period passes, they will then update their report if they want at their discretion, taking into account the comments that you have provided. And then they will then issue that to the members of the Information Regulator, like the actual committee that makes the ruling on an enforcement notice. And the outcome from that body within the regulator, that will then be the enforcement notice if there is one. And then there is an enforcement notice. And again, if there's anything in there that says, look, we picked up that there are gaps in your direct marketing compliance, we'd like for you to correct it. You're again given an opportunity and time to do it. And, if it's 1 month or 2 months, they usually look at a period that is enough for, that is proportionate to the gap that they have identified. And it's only after that, then if there's still non-compliance, that is when the fine will come in. So there's quite a long process that can be drawn out over a couple of months. So just to give you an idea, one of the ones I dealt with recently, there was a visit. And then, 2-3 months later, that's going to be when the draft report comes out, and it's going to be another month or two after that before the final report gets issued. So it is quite a lengthy process. And what the regulator has cautioned in these visits is that whatever they say in the meeting, in the visit itself, or even in their draft report, organizations aren't supposed to be going off and now just implementing for all what they think the regulator is going to find, or what the regulator's team has indicated in their draft report, because that final report and that enforcement notice might look very different. So they do caution against doing that. Then the other thing just to mention is that in the heads up you get on the visit, there will be an indication of what the plan is. Is it going to be, a couple of hours, or is it going to be spread over a couple of days? And what are the topics that are going to be discussed? And it's literally a breakdown. So we've seen it from being very simple to very robust. In terms of the robust approach, and that's what I'm going to be discussing over these next few slides, the robust approach looks at everything, and the agenda will be quite detailed. It will say, we want you to speak about your organization, like what is your business about? And we want you to speak about your processing activities. Are there people in this room that are able to talk about, the accountability condition, the processing limitation condition, what practically you have in place to comply with it? They'll actually want, a step through of that. And they could also talk about other POPIA matters outside of the processing conditions. It could come down to your direct marketing practices, cross-border flows, and things like that. And they could also have a slot that's in the agenda for whatever might have been the trigger for the visit, if there was one. So if there was a data breach, or there was a POPIA complaint, for the organization itself to be able to respond to those issues as well. And very much like with the PIA audit here, there'll also be things like staff interviews, and they will interview random people in the organization, and they deliberately will interview people who do not have senior authority. They want to see that even at the most junior level, the staff have an understanding of their role, to assist the company with its POPIA compliance. They know who their information officer is, and they know what their duties are to assist the organization with its compliance. And they're not allowed to be accompanied by anyone that is senior or who is even involved in the audit as well. So it's done solely by the regulator, and they often divide their team and they spread out in the organization. And the physical inspection as well. Oh, sorry, lady.
Sorry, oh yeah, Priyanka, I would just like to add also when it comes to the visit, it's important to know that the visit doesn't start when they get to the boardroom or whatever assigned room. The inspection starts when they get to the grounds. So from the security, when they enter the gate, receptionist, all of that. So that also gives you an idea of how comprehensive and that they're looking at everything and not just the documents you have in place, or not just your answers during the formal audit, but everything is being taken into account.
Absolutely. I mean, one of the ones that you and I worked on, the lady, the regulator said, when we arrived at the front desk, your receptionist took our picture. Where's our picture going, and why do you need our picture? And we didn't see a link to your privacy policy and the sign up visitor form. So it's things like that. So when you do get the prep or the notice that there's going to be a visit coming, you almost have to step into the shoes of the regulator and be like, okay, where would they come in? And at our boom gates, are those security guards under our control, or is it our landlord security guards? Do we have an operator contract in place with the security company if it's our third party and not the landlord's? Where is information going? All of that. So it is actually very important. And even the physical inspection, we have to bear in mind that POPI is not limited to electronic information, it's all information. So if you have departments that are quite paper driven, like HR is often a very paper driven department, they might go to the HR department and have a look at the filing cabinets, how is information stored. They might have a look at your desk stations where your printers are kept, are records just lying around, all of that. So it could be quite comprehensive. What I'll share with you is when the visit does actually happen, the idea is that you have someone knowledgeable enough about how your organization processes information to be able to speak to these issues. So we have found there is a focus on the processing conditions in these audits because it's the bulk of POPI from a compliance perspective. And they're not necessarily wanting to see documentation during the visit. They might, but from what we have done, we actually compiled files just in preparation for any questions that could come up, because it's quite consultative, as I mentioned. So there'll be this agenda and they'll follow the agenda. They might even move items around depending on how the day is progressing. But they might start off with, okay, let's have someone from the organization speak on these processing conditions. And then their team will actually ask questions as you're discussing. So you could be speaking about, so for the accountability condition, we've appointed an information officer, there she is sitting there. And then the regulator might say, okay, but do you have DIOs as well? And if you don't, why not? What decision was made to lead you to not appoint DIOs? Or they might say, you're pointing to someone who we actually don't have on file on our side. We have someone from 3 years ago. Is that not the same person? So it is interesting. And what we've also seen is how they've interpreted the accountability condition. The accountability condition in POPI is quite not flat, but it is quite vague. It just says, the organization has to be processing information lawfully. It has to be accountable. There hasn't really been tangible outcomes from that condition one, but in the audits we've seen, the regulator has looked at, for example, who your information officer is, who your deputy information officers are, what policies you have in place at an organizational level, and for you to be able to comment on those. Bear in mind that whatever you say in the visit is recorded. So you shouldn't be saying something or that you can't back up if they do have to ask for that information after their visit. So if you say, we have a data protection policy in place, they might say, cool, can we look at it? Or can you provide it to us after this audit? So whatever you say needs to be justified as well. And the panel from the regulator, it's often chaired by a lead. They have a chairperson for the panel who will be the one driving most of the questions. That person could be supported by anyone else as well. But there are also sort of like subject matter experts that they have on the panel as well. They could have a security expert, and that person might be asking all the questions on condition 7 and specifically the company security posture. That person could also be interrogating the data breach if there was one that happened. So that's an important thing to bear in mind. And there could also be other subject matter experts as well. What I noticed in one of the last audits I did was some of the other subject matter experts were misinterpreting POPI. In the questions, they were almost asking the organization a question based on their interpretation, almost making it seem like it's almost like leading the organization to admit fault to something that has actually been interpreted incorrectly. And that's where the role of your lawyer actually can come in to, before the organization actually responds to the question, to test what the regulators personnel has actually asked, and to say, where do you find this? Can you explain this so that we can understand exactly what you're testing for? Because there's different personalities on the panel, so that is something to be mindful of. Of the other processing conditions as well, condition 2, massive one. We see the regulators very, very curious about an organization's processes around consent. So if you are relying on consent, and the view that the regulators panel has expressed so far is that, which echoes my own view as well, is that consent shouldn't be your primary source of processing. It's a tricky ground to rely on, but they say when you are relying on it, what does it look like? And they're very curious about direct marketing consents. Are your consents hidden in your contracts? They had even asked for a sample contract to be shared up on the screen as well, to test whether you're getting deemed consent, which I know one of the questions was asked about it, but you can't hide opt-in or deemed consents in a contract if you're trying to look at direct marketing. So they were very curious about things like that. They also had a very, very strong focus on PIAs, which are your personal information impact assessments. And as Wilmarie mentioned at the beginning, we are not seeing organizations do this at all. It's one of the explicit obligations on an information officer in terms of the regulations, but it's one of the ones that companies just really don't focus on. But it was a massive focus for the regulator, is wanting to understand, have you classified your information? Have you identified processing flaws? Have you plugged those flaws? Are you able to identify your operators, security measures for the kind of information you process? All of that they're expecting to be captured in your PIA. And I did also, in one of the audits, raise the question to the regulator and say, we haven't actually seen guidance from the regulator on what the PIA looks like. When our team advises clients, we actually look towards the UK and the EU's approach to data protection impact assessments, because there's a lot more guidance from the regulators there on what those look like. So again, another example of how you can actually use the session to gauge from the regulator what their view is and what their expectations are as well. Condition 3, very big for them as well, was the data retention policies that organizations have. Is cool, you have the policy, but what do you do with it? Like, as Wilmarie mentioned at the beginning, you could have a really great policy, but if you're not implementing it, that's actually their bigger concern, and rightfully so. You could have a policy that says that you delete information after 10 years, but is it actually being done? And that's what they also test, is they look at policies that are all being pushed out by the information officer and sitting somewhere in the organization. But if they ask the head of the customer services, what do you do with customer data? That guy says, we keep it. so there's a bit of an internal disconnect between heads of your operations in the company and actually what's being done from a policy perspective. So it's, those are things that they are testing, is implementation. Like, you've got the policies, but what are you actually doing? And that's where a lot of the focus is. So conditions 4 and 5 are also obviously important, but the focus from regulator has been on like conditions 1, 2, 3, 6, obviously, is the privacy notice. They interestingly drew a distinction, and I'm also trying to adjust the way I term my policies now as well, but they also drew the distinction that I've seen the regulators in the EU and the UK also do, which is there's a privacy notice, which is what you have on your website, and there's a privacy policy, which is organizational guidance to employees on what to do with information. So, and I think that's correct. I mean, Section 18 is a notification obligation. It's a privacy notice obligation. So they were very curious about how the organizations deal with their notification obligations. Condition 7 and Condition 8, it might depend on, again, what triggered the audit, because if it was an audit triggered by a complaint, they might have a whole separate segment specifically on data subject participation, which is Condition 8, and looking at the processes in place. Or if it was a data breach that triggered the audit, they might say, look, we're not going to deal with Condition 7 today. Let's just go into the data breaches fully tomorrow. That's when you discuss your security measures and all of that. And again, they're going to look at not just your IT team's security measures that they implement. They're going to look at physical measures that you have in place as well, like locking up your filing cabinets and all of that. So just some things to leave you with from what I've mentioned now is when you receive that notice that there's going to be a visit, the first thing you do is you say, okay, what do we have in place now? Let's just look at what we have. Where do we need to go to? If we involved this law firm several years ago, do we need to go back to them and ask them for copies of that? Or have we been maintaining our documentation since then? What do we have? And do not try to fix issues before the regulator comes, because it can look really dodgy if the regulator has already seen what your website says. Your POPIA manual is sitting there and it says last updated July 2021, and then the day before they arrive, it suddenly says it's been updated July 2025. It just doesn't look transparent with your engagements with them. You can still do a lot, but you're speaking on your processing posture. So what you do in the 2 weeks leading up to a visit is not going to be what your processing posture is. So it's better to rather position things as saying, we've implemented stuff, it's ongoing compliance for us, we're entering into refresh cycles, this quarter or next quarter. There are ways to position gaps in your compliance. So you need to be strategic about that and not open yourself to scrutiny, for trying to fix things before the regulator comes. Know who your presenters are. Make sure that they are empowered within each of their spaces. Do mocks with them. We've done mock sort of audits with our clients to prepare for questions. There's a way to answer the questions. There's a way to deal with the questions as well. And you need to put people in the room who are clued up on POPI and do not accidentally say something that's out of turn or even incorrect, that's not actually reflective of what the organization's doing. So that is important. Yes, I've mentioned those things. The request for information is a very similar process. I'm not going to go into it in too much detail. Slides will also be provided, but again, you want to, I think the main point for me to express here that's different from the visit is do not doctor your documentation. I mean, again, so if you are requested to provide, certain information, do not hold back certain records because they're not suitable or they're not they're not compliant, because doing so is not complying with the regulator's request. Those notices are binding on organizations. There are fines, there are consequences for not complying with those notices. You can always say something like, look, this document is legally privileged, I can't put it up. So at least you're responding to something, but just be mindful of how you package the documentation. For the clients that I've assisted with this, I've actually said, for item 1 of your request, please see attached. Item 2, we don't have this. This is our strategy. This is our plan. This is our position. So you almost provide a bit of a story that you hand up to the regulator. Okay, so I'm gonna park there on Poppy audits. I hope it was helpful. It is actually this time. I think that's the main thing to get across is that you have time, and if none of you are facing an audit right now, at least you can have an idea of what can happen and start looking at ways to make sure that your current compliance is responsive to the law. I think that's a good place for me to hand over to Naledi for the last section.
Thanks, Priyanka. So for this last section, we're just going to be discussing how to sustain and have a living privacy compliance program. Like as we've said, compliance is an ongoing issue. It's not that you get your documents in place the one time and that's it. But what we're basically saying is that it's a continuous thing, and you need to make sure that you are continually looking at what measures are in place and improving them or making changes as needed. So in terms of the regulations, the POPIA regulations, this is actually one of the stated obligations and responsibilities of an information officer, in an organization. An information officer must ensure that there's a compliance framework in place. It needs to be monitored, it needs to be maintained. And with the latest regulations that Priyanka touched on earlier, there's also this added wording of and continually improved. So which basically underpins what we've been saying is that there's an obligation to make sure that compliance is ongoing and not just a one-time thing. So then I think, what is a compliance framework? And unfortunately with POPI, or maybe it's just because I don't think it's an infant anymore, but it's still a young piece of regulation. We don't really have guidance in terms of what a compliance framework would look like. And in the table that's projected, you'll see there's different ways or different things that clients will interpret what a compliance framework is. So you could have a data protection compliance manual, you could have a checklist, or you could even have a program. And these different deliverables, they require, or the purpose of them are different, and also the format in which they're used and the format in which they are presented are also different. So it's always important to kind of figure out what exactly you need in your organization. Is it something very comprehensive? Are you needing more of a checklist so that when you do your annual or regular audits and assessments, internal assessments, that's an easy thing to do? Or do you need more of an overarching program, which is more of a strategic plan, which would then speak to how data protection compliance is then monitored throughout the organization. So on this slide, we just basically have an example of what we call a compliance tracker. And it has like various aspects of data protection compliance. And so then this is used more as a checklist. But for some organizations, they find like this is a very practical tool to use. And this is then what their compliance framework looks like on top of other documents and other policies they might have in place. So determining what the compliance framework looks like, I think at the end of the day will depend on the needs and the processing activities of each organization. That being said, I think Priyanka has said a lot about what happens at the audit, and Maria has also said a lot. And so the question then on everybody's mind is, okay, then how do we make sure that at least we're ready now that we've attended this session? What do we need to do? And so the next few slides, I'm going to be speaking on a checklist and what your ongoing compliance checklist needs to look like. Hopefully, the column on initial compliance measures has already been implemented in your organization. And if it hasn't, you still have time, and you should probably get on it as soon as you can. So the first one is the appointment of an information officer and a deputy information officer. First steps is appointing one, as we've spoken about, and usually this is also having that appointment letter in place, or a delegation or a letter of delegation in place. And then secondly, registering the individuals on the e-services portal. In terms of ongoing compliance, it would just be making sure that if you do have or add deputy information officers, or if the information officer or deputy information officer step down, that those details are updated on the e-services portal, but also in the separate or the various policies you have where they might be the named individual. Another thing is to also make sure that the information officer has or is attending ongoing training and is quite aware of what's going on in terms of the industry when it comes to data protection standards and just generally what's going on there. Then when it comes to lawful processing conditions, as we've spoken about, the first thing would be to identify what personal information is under the organization's control. So this could be in the form of a record of processing activities, document a ROPA. This is also part of the PIIAs that Priyanka touched on. Sometimes we see that creating a data map helps give a very good overview and detailed understanding of what information and what personal information is being processed, where is it being collected, who processed, what division or department is processing the personal information. After it's processed, where is it stored, who has access to it, are there any third parties that process it on behalf? So it's quite comprehensive and it gives you an idea of what is actually happening when it comes to data processing within the organization. And then what's also important is identifying what the legal basis for processing personal information is. As Priyanka said, it's not just consent that you can rely on. Sometimes you can rely on, the fact that there is a contract in place or a legitimate interest assessment, a legitimate interest there. So it's things like that that you need to identify at the very beginning. And then in terms of then ongoing compliance, it would be updating your ROPAs. Also then continuously updating and reviewing your data maps as well as any data inventories that you have. So just because 2 years ago you were collecting information or you're processing information related to students, it doesn't mean that that's the case now. And it's always good to have an understanding of like if there's been any changes, if there's been any new services perhaps that your organization is now offering and is catering to a new market, if there's been a change also in the structure of their organization, that's going to affect how the information is being processed within the organization. And that needs to be reflected in your updated data maps as well as your inventory list. And then when it comes to training and awareness sessions, there's initial training that usually happens or should be happening. And then in terms of ongoing compliance, you'd then be expected to be conducting refresher courses and also for new employees, also providing providing training there. Also, in order to test whether the courses and the training is actually working. So I know in ENS, every single month now we get a test in terms of cybersecurity and data protection principles. And I know there's a few people who have failed it and they get retested a couple of times after that. And that's just to make sure that employees are aware of what's going on and they are helping and aiding in terms of compliance with data protection legislation. It is also quite interesting for us. I think about a year ago, we read a statistic that 60% of your cyber risks or any like data breaches or security compromises are because of employee behavior. So the risk is internal more than it is external. And that's why training and awareness sessions and ongoing ones at that are quite important. And then policies and standard operating procedures. Yes, you have implemented, well, you've drafted and you have adopted these beautiful policies. They're quite detailed and hopefully you've also implemented them. But then it's also important to review them. I think depending on the content and depending on what the processing activities that are being undertaken in the organization, that's what will basically let you know how often you need to do the review. But in terms of our advice, we say at least once a year. Further things to consider is your security safeguards. What security safeguards are in place? Let it be technical, organizational, or even physical security measures. Determining what those are in place, and also then determining what other ones need to be in place. And that would be the initial first step in terms of complying with condition 7 of POPIA. And then also having a data breach response and notification plan in place. In terms of ongoing compliance, and because security standards are evolving so fast, especially with the technology that's in place, you know, what was effective literally 6 months ago might not be what's like the best practice. And so you need to evaluate whether those security measures that you have in place are still adequate in terms of, you know, the emerging threats. Like now with deepfakes, you know, do the measures that you have in place, do they guard against things like deepfakes, and things like that to just think about. Another thing is maintaining a data breach register, and making sure that you have an idea of, or you can at least say, this is what happened, or we had a data breach on this date, and these are the steps that were taken to mitigate against any further risks, and all of the other things that need to take place there. And as I've already spoken about, security awareness training, that is definitely a must. Something that cannot be just a one-time training in a year based on how risky processing of personal information and just the risks out there are right now. Then we have data retention, and sorry for that typo on screen. It's one thing to have a data retention schedule that says all these lovely things in terms of this is how long we keep that information, and this is the information that we hold. But what is really important is to make sure that you're operationalizing that data retention schedule. So are you actually deleting the information within those periods that your data retention schedule is saying? How long is the information being held? Also, how what methods are you using in order to dispose or distract any information that does no longer need to be held by the company? And then we have personal information impact assessments. We have touched on this already, but in terms of ongoing compliance, we'd expect when there is a big change in terms of restructuring, if there's any other new technologies that are implemented or adopted within the organization that would necessitate a PIIA to take place. I think also if there's changes in the services, which we've also spoken about. So PIIAs are definitely things that need to take place more regularly, as we've said, and we're seeing that organizations are not conducting PIIAs as often as they probably should. So what I've just spoken about are all the internal things that need to happen. And then for externally facing requirements and obligations, there's also ensuring that data subjects are able to enforce their rights. And that would basically mean ensuring that the contact details of the IO are up to date and they can be easily accessible. In terms of ongoing compliance, then this is where you have a register specifically for data subject access requests under PIA, but also continuous training again, training employees in terms of what you need to do when you get a request from a data subject under PIA or POPIA. And then direct marketing. You have to have those opt-out mechanisms in place in all your communications, whether it's SMSs, whether it's emails, your cookie banners or your cookie notices and all of those good stuff. And also then creating a consent register. And this is really important to have at the beginning, because then you have to maintain that register to make sure that people who have opted out are opted out, and that you're not contacting people who have opted out, and making sure that your register is kept up to date. Because I don't think I'm speaking only for myself, but it's very annoying when I've opted out of receiving direct marketing, and then I keep on receiving the direct marketing, no matter how many times I click unsubscribe. And I think, it's things like that that lead to complaints to the Information Regulator. And then lastly, we have contracts with third parties, and specifically referring to your operator agreements. So at the very beginning, you need to identify who your operators are. And sometimes it can be difficult in terms of identifying who these are, but once you undergo that initial exercise, it's going to make your life much, much, much easier. And so once you identify who your third-party operators are, then you'd want to conclude an operator agreement with them or amend existing agreements with the operators to make sure that they include adequate and sufficient POPI operator provisions in that. And then from an ongoing compliance perspective, there is definitely a monitoring and a quality assurance and exercise that needs to take place with your operators, making sure that they're complying with the provisions of the contract, and making sure that their security safeguards that they have said are in place are actually in place and they're adequate in response to the processing that they're doing. Also making sure that at the end of the contract, they're actually deleting or returning any personal information in their possession. So basically that's some of like the action orientated or like some of the actions that need to take place from an ongoing compliance perspective. Of course, there's so many more that we could discuss, but we don't have time. And also then it becomes more specific per organization. And so I think here, if you scan, and I know we just have a few minutes left, but if you could scan the QR code again and retake the quiz. Not that this presentation was meant to scare you, but I think you will realize that there's probably one or two or even more things that you weren't aware of that you should be aware of, which might impact how you feel and the confidence around your data protection compliance program so far. So if you could just indulge us in that way.
I'm seeing the numbers drop already, but well, maybe perhaps you can just close off while people are still engaging with the poll.
Yeah, sure. So we have been going through your Q&A, and thank you for all the questions and interacting with us. Yeah, I mean, we can't, there's still a few questions there. I don't think we're going to have time to go through them. Just in terms of Form 4, in terms of the new regulations, like Priyanka said, they have made it a little bit easier. I think the previous form was like 3-4 pages long. So they've removed some of the formalities, and like Priyanka's also said, they've now allowed for you to use that information and get consent through whether it's WhatsApp or an SMS or online platforms that you use. As long as you have wording in that consent that is substantially similar to that contained in Form 4. So you don't have to use the form exactly. But they have published the form and you can see the information on there. So yeah, I mean, in the last minute or so, Priyanka, do you want to let us know what your feedback was on the poll?
Yeah, look, people are still responding. I think it's good to see that a lot of the organizations represented here in the room today are still somewhat confident that they'll be fine, and that's good. That's really great and really encouraging for us, I think, to know that there are organizations out there who are still doing the good stuff. And for those who are saying, you know, look, we're not very confident, or we still have areas for improvement. There's time, and I mean, this is an ongoing thing. It shouldn't be the threat of an audit, you know, that kind of keeps you there, but it does help to have someone like kind of like on your back a little bit, because the point is ongoing compliance and making it data subject friendly. So I hope there's more from our regulator on how to make compliance more practical and easier for organizations. But it's the results in the poll are nice to see, actually.
Yeah. Yeah, we hope that the session was useful. Yeah, I mean, like Naledi said, the intent is not to scare you, but to give you guidance on exactly what it is that the Information Regulator looks at. And I think for me, as a closing or takeaway, if what the one thing you take away from here is understanding that having policies and procedures in place is not sufficient. You need to ensure that there has been practical implementation in your organization. So doing internal audits, training your staff, and making sure that your policies and procedures, as fancy as they are, that they are actually being implemented operationally is quite important. You will all receive the slides and a recording of the session. If you have any further questions or you do get that notice for that audit, you know where to find us. Thanks, everyone.
Thank you, everyone. Thanks for me and a lady.